All right, so I wanted to continue this conversation with Juan Galt. So far, he has not mentioned actually having a conversation. He keeps going back and forth on the YouTube comments. So we'll address some of the stuff that he's saying, and I want to start this by saying that I do understand what Juan is saying when he says that the courts, or at least some of the courts, have declared that the word state includes the 50 states, that's just something that you always accept, and that everywhere that you see the word state, it always includes the 50 states. And so when it uses the word includes, it's only adding things to the original definition. So in this video, we're going to go through some of this to explain, hopefully, why I disagree with that assessment. I think the Supreme Courts that ruled on this, and you'll actually hopefully see my point here in a second about these cases that Juan is putting forward, and why I don't believe that they hold any merit anyway. But hopefully, we'll get to the crux of this problem. So I wanted to start off with Juan's comments. So this is from United States versus Munt. And it says, on the merits, defendant argues that the district court lacked jurisdiction over him because he is solely a resident of the state of Michigan and not a resident of any federal zone, and is therefore not subject to any federal income tax. This argument is completely without merit and patently frivolous. Now, every case that Juan is going to put forth, that is that is the response. It's frivolous. There is never, at least I have never seen, any of these Supreme Court judges, or whatever this wasn't, or actually that one was, but some of them are not Supreme Court cases. But I've never seen the judge actually explain why he is saying what he's saying. Because and we're going to get into the definition of includes and including and all that kind of stuff in a minute. But the bigger point is here's another response that says, Muck of Beecraft reply is also devoted to a discussion of the limitation of federal jurisdiction of the United States territories and the District of Columbia, and thus the inapplicability of the federal income tax laws to a resident of one of the states. This claim also has no semblance of merit. And this is Lowell Beecraft. Nelson was fined $2,500. So, and again, I'm not arguing that these cases did not happen. I can provide you plenty of Supreme Court cases where the judges were absolutely wrong in the decisions that they made, and some of them have been overturned. So going on the assumption that you should just do something simply because some judge on the Supreme Court has made a ruling that just says, oh, that's frivolous, but he never actually explained his position, I think it's utterly ridiculous. So maybe one day someone will get in front of the Supreme Court and have those decisions overturned, but that's another day. Right now, I'm trying to put forth the argument that they are wrong. So what you'll see are a lot of comments. He provided a lot of 5 or 6 Supreme Court case. Here's another one along with his claim that he is not a United States citizen. Plaintiff further claims that federal laws, including IRC, do not apply to citizens of the state of Washington, a compact state. Article 1, Section 8 of the United States Constitution grants Congress the power to lay and collect taxes. The 16th Amendment, which, by the way, the 16th Amendment very recently, like I think in 2022 or 23, or maybe even 24, the Supreme Court finally laid down exactly what the 16th Amendment is talking about, which is on excise taxes. It never overrode or got rid of the taxing restrictions that were placed on the federal government. and it's always been an excise tax. And an excise tax is a tax on a privilege, something that you don't have to do. Well, earning a living is a right, it's not a privilege. And so the question would become, what is the privilege? What is the perceived privilege if income taxes, the ability to tax them via the 16th Amendment, is taxing an excise tax? What's the privilege? And I've yet to have anybody actually explain what that privilege is, because it cannot be that I have a privilege to work and earn a living. But anyway, going on, land collect taxes, the 16th Amendment provides that Congress shall have the power to land collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration, pursuant to the authority vested in Congress under the 16th Amendment to impose a direct tax on the citizens and residents of the United States comprised of the 50 states. And again, he's just saying that it is not what the code says. Comprised of 50 states and the District of Columbia, Congress enacted Title 26. All right. So again, he's making a declaration, but he is not explaining what he's talking about. He's not providing any examples. And again, the 16th Amendment, even before the recent ruling on the 16th Amendment, the Supreme Court had already ruled on the fact that the only way that the 16th Amendment could be constitutional is if the tax that it is imposing is an excise tax. It had already ruled multiple times on that subject. But for some reason, the Supreme Court, and this is just another example of why I have very little respect for the Supreme Court, for some reason, the Supreme Court was split 50-50. Some courts would recognize the fact that it was an excise tax. Some courts would actually treat it as if it were a direct tax, and that the 16th Amendment gave the federal government the ability to not have to apportion the money, or the taxes. So it's kind of confusing if all this stuff is so black and white and simple, why even the Supreme Court couldn't agree on what it was actually saying. And then it says here, Ward makes three arguments on his appeal. First, he suggested that the United States has jurisdiction only in Washington, D.C., the federal enclaves within the states, and the territories and possessions of the United States. And that is a true statement. The federal Supreme Court has ruled, I've got cases where they specifically said that the federal government doesn't have jurisdiction inside the 50 states. It only has jurisdiction inside of the things that are listed right there. And so it says he interprets the term individual within the Internal Revenue Code to apply individuals located in the jurisdiction of the United States, which is reasonable. Ward reaches this twisted conclusion by misinterpreting the portion of the Income Code. The 1913 Act defined the word state or United States to include the United States territories and the District of Columbia. And it's when you read this stuff, it's kind of hard to believe these people are actually judges. Yes, the United States includes the territories in the District of Columbia. Those are federal territories, so of course they include that. It depends on which term you're actually using. And by the way, the Supreme Court has actually ruled on that too, that the term United States is not only used to reference the continental United States. In fact, it rarely is used to reference the continental United States, and it almost exclusively references the District of Columbia or the federal territories and enclaves. So his statement, while not in factual, is misleading. And then it says Ward asked the court to interpret the word to include as a term of limitation rather than a definition. It's not a limitation. Everything in that word, when it is defined, and again, if the United States always refers to the entire country, then why are you giving me a definition for the United States? That's the first question. The second question is, if the term is only listing, it uses the word includes, and it's only listing federal things, how are you coming along and adding non-federal things to that definition? Because they obviously gave you the definition for a reason, but we're just going to ignore that reason and apply what we believe is the 50 states is always part of the United States. and ignore legislation and the Constitution that shows that that is not always the case. So those are my arguments. I'm not going to go through all of the stuff that he put in here because it's all the same stuff. And right here, we find each of the appellant's contentions to be utterly without merit. That is their favorite thing to say, but they do not ever specify exactly why it is without merit. Like, what are you using to make your determination that it is without merit? So again, Juan, I agree. There are constitutional cases out there, or not constitutional cases, but there are Supreme Court cases out there that say that it is without merit. But I'm asking you to supply something to explain why it is without merit, because I'm about to show you that it is definitely with merit. So here we go. So the first thing that I want to talk about is a couple court cases. So we're talking about the term state, and we're trying in United States to some degree, and we're trying to determine whether or not it includes the 50 states. So in Allison Company versus EVAT 1945, it stated the term United States may be used in any one of several senses. It may be merely the name of the sovereign occupying the position analogous to that of other sovereigns in the family of nations, which would be like the continental United States. It may be designated to, or it may designate the territory over which the sovereignty of the United States extends. That would be D.C. and territories and enclaves, military bases, those types of things that the federal government has jurisdiction over. Or it may be the collective name of the states which are the united by and under the Constitution. So there's three different ways that this particular Supreme Court has defined it. Now, since then, the federal government has come up with even more ways, because there's definitions for the United States that define the United States as a federal corporation. There's definitions that define the federal or the United States as being all sorts of things. So to just say that the term United States always includes the 50 states, that is just utterly wrong. There's nothing, I mean, there's lots of Supreme Court cases that say otherwise. All right, so now, just before we go on, let's take a look at the 10th Amendment. This is in the Constitution. So in there, it says the powers not delegated to the United States by the Constitution, nor prohibited by the states, by it to the states, are reserved to the states. Well, obviously, the term United States in the 10th Amendment is not referring to the entire country. It's not referring to the 50 states. So my big contention here is that when you have a term that literally has multiple meanings, and you go to a code section and don't give any specific meaning to it other than to list federal territories, well, then one would have to assume that you're talking about the federal government. You cannot just go in and say, well, I'm going to use what I think needs to say, and this includes the 50 states. I mean, to me, that's just utterly ridiculous. All right, so then let's look at Caja versus United States, and it states this statute, and we won't worry about what it's even talking about. This statute is one of universal application within the territorial limits of the United States and is not limited to those portions which are within the exclusive jurisdiction of the national government, such as the District of Columbia. And it goes on to talk about the 50 states and the fact that the federal government doesn't have any jurisdiction in the 50 states. The primary point here is that the term United States and state, you cannot just assume what they're talking about. So now let's continue. And this is another definition for the word includes that's a little bit more clear as to what it is that they're talking about. Typically, when they use the term includes in law, it is an exclusionary thing. Once you provide a list or start providing a list, those are the specific things that are within that code, unless they use a definition like this, which is talking about the class of the things that are in it. So it says the term includes, including, do not exclude things not enumerated which are in the same general class. And this is the same basic definition that they provide you in Title 26. It's just a little bit harder to understand. So I just wanted to kind of give you this. So general class would be, if I start listing federal enclaves, then you can add other federal enclaves into that definition, but you can't go add Germany and France. You have to stick to what is listed in that particular definition or the class that they provide. All right, so now here we go. The original Social Security Act of 1935 in Title 11 General Provisions stated the term state, except when used in Section 531, includes Alaska, Hawaii, and the District of Columbia. Okay? The term United States, when used in the geographical sense, means the states, well, they just gave you the definition of states, Alaska, Hawaii, and the District of Columbia. Here it is, an actual screenshot of that code section or that title or act. So now what we looking at this, if you were to look at what's here, we have Alaska, Hawaii, and the District of Columbia. This is from 1935. Alaska and Hawaii were territories and possessions, and the District of Columbia is obviously a possession. And so these are all federal enclaves or federal territories, however you want to generically declare them. And so it would be perfectly okay to add other territories into this code, and you would have to accept them because they fit within the category of that particular group. All right, so now that particular code section, this whole 1935 income tax thing or Social Security Act was codified into 3121E, which is, and I'm speaking specifically to this definition, it was codified into 3121E for state in the United States, and that's where it currently sits. Okay, so when it got codified, this was the definition that got put in there. Okay, so now, and Alaska became a state. And when Alaska became a state, they had the Alaska Omnibus bill, and it went through and it modified a bunch of USC codes to reflect the admission of Alaska into the states of the Union. And look what it did when that happened. It went in and it says, 1954 related, it says, and sections 3121E and 4121, all these of such code, each relating to a special definition of state, and are amended by striking out Alaska. So when Alaska became a state of the Union, this definition removed it from the definition for state, which seems utterly ridiculous if state already included all of the 50 states. They could have left it alone and it would have been perfectly okay because it was already including those things. Now, you could argue, and I'm sure Juan is going to attempt to argue this, you could argue that the reason that they took it out was because the term state already included the 50 states, and therefore they were cleaning it up or whatever. But again, it doesn't really make a lot of sense. Now, what really makes even less sense, and to me, this actually kind of changes things even more, is the fact that the term United States also included the exact same thing that was listed in the definition for state. It included states, but it includes states, Alaska, Hawaii, and District of Columbia. So when they get ready to change this, they also removed Alaska from the definition of the United States. So it's a little weird to claim that the word state includes the 50 states. You convert a territory into a state, and you have to modify that particular definition to remove the state from the state, because now it is a state. It's just odd. I'm not, and here's my big point. This is if this includes the 50 states, and I've already given you enough evidence to know that the United States does not always refer to the 50 states. But if it refers to the 50 states, it is extremely odd that they would go through and have this definition at all. I mean, you would think that they would actually say it includes the 50 states, Alaska, Hawaii, and whatever, and be done with it. Now, and another interesting thing is that we've had Supreme Court cases for years talking about this subject, about the fact that the word state does not include the 50 states. And not one attempt has been made by the legislature to correct the problem, to eliminate all of these people having to go to court and fight the system over a definition that they could have simply gone and modified and made it what it was supposed to be. Now, I'm going to argue that they can't modify that definition to include the 50 states. And the reason that they cannot is because the federal government doesn't have jurisdiction in the 50 states. It does not have jurisdiction in the 50 states. And if you go back and watch all of my income tax videos, you'll see that it doesn't even matter, because none of this actually applies to any citizens in the 50 states unless they have something to do with you know what. So let's go on through this. So now we get to where Alaska had been changed, and now Hawaii becomes a state. And what do you know? They do the same thing. They strike out Hawaii. So, and here the term United States, when used in geographical sense, includes these things. This is what it currently reads. So the term state includes the District of Columbia. It doesn't say that it includes the 50 states. It's just very weird that it would say that or use that terminology and not include the 50 states. Now, you've also got 7701A10, which is really the primary thing that we're actually discussing. But the Title 26 does return. So there's a code section in Title 26, and it's 26 USC 61035A. And it defines the word state. Now, in this particular code section, it's talking about protection of your personal information. But look at the way they defined it. The word state. Any of the 50 states, the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, American Samoa, and the Commonwealth of Northern Mariana Islands. Now, so evidently they know at certain times that they need to put this in here. So the question becomes, if the definition for state always includes the 50 states, why does any definition inside of the USC ever refer specifically to the 50 states? Because again, the USC, and this is something that people don't understand, the USC is federal codes. Those codes only apply inside the states if they are related to some constitutional power that was granted to the federal government. The federal government within its enclaves and territories has supreme dictatorship. It literally can pass any law it wants and do anything it wants. There are no constitutional limitations for the federal government inside of Washington, D.C. However, if it is going to pass a law that has something to do with the 50 states, well, now it can only do that if that law fits inside of one of the powers that were granted to it. So as an example, banking. The federal government was granted the power over the banks, or not really the banks, but over money. And so if it passes a law that has anything to do with money, then the states are required to follow that particular law. But if it comes along and passes a law that says that you can no longer carry guns, there isn't a single state in the union that has to follow that law, because it isn't law. It's a law on the books inside of Washington, D.C., but it is not a law on the books inside of the 50 states. So And the Constitution is very, very clear about all of this. It's not, I'm not making this stuff up. It's very point blank and very clear. And so the point here, and that's, I'm just talking here on the 6103 is where they're talking about the protection of your information. So the point is number one, the definition for the United States does not always include the 50 states. It cannot. It's not. That's not the way that it was ever written, and the courts have recognized this from way back in the 1800s. So you can't assume that you know what the definition is including unless they specifically tell you what it is including. The definition for state also does not, it cannot include the 50 states in every sense that it's being used, because the federal government doesn't have control over all 50 states. It likes to pretend that it does, but it in fact does not. And so it's necessary to understand specifically what is being discussed when you're looking at these code sections. Now, the funny part about this is that I'm going back and forth with Yaun over this definition because he thinks that this is the primary thing that I'm hinging all of my arguments on. And it really has no relevance whatsoever. I mean, it does have some relevance because of the things, but it really, at the end of the day, doesn't change the fact that no private citizen in any of the 50 states is supposed to be paying this income tax. And I can prove it, Yaun, if you'll ever get on the phone with me and let's have an actual discussion and go through this stuff instead of this, one-off, here's 10 cases and they're the same old crap that the IRS gives me over and over and over, and none of them actually address the specific things that we're actually talking about.